You've probably all heard that the Massachusetts Supreme Court made one of the most boneheaded decisions ever known to the right to keep and bear arms. It said the following. I'm not going to quote. I'm going to give you the two elements. The Massachusetts Constitution does not protect an individual right to keep and bear arms, number one. And the Second Amendment, as law currently stands, has not incorporated the right to keep and bear arms in or through the 14th Amendment. So, what can we, if we take those two statements, just those raw, bare statements, the Massachusetts Constitution does not protect an individual right to keep and bear arms, okay? And as current federal law stands now, the Second Amendment is not incorporated against the states through the 14th Amendment. What is then the conclusion? What is the court saying? The court is saying that for a 14th Amendment citizen, and this is crucial, this points out the hidden evils of people not understanding the 14th Amendment and not understanding that it doesn't apply to them. The Massachusetts Supreme Court just said 14th Amendment citizens do not have a right to keep and bear arms. Period. Period. No discussion, no question. You don't, if you're a 14th Amendment citizen, you don't have the right to keep and bear arms. Now, that's almost certainly due to change, because the odds that the United States Supreme Court is not going to incorporate the Second Amendment through the 14th Amendment against the states in the Chicago case that it is hearing right now, or the McDonald case, depending on how you want to phrase it, are very slim. Very, very slim. The odds are overwhelming the United States Supreme Court is going to incorporate the Second Amendment against the states through the 14th Amendment. However, I want to go back to the Massachusetts ruling. Because what else does the Massachusetts ruling say? Not what does it say in text, what does it mean? It means 14th Amendment citizens have no inalienable rights. 14th Amendment citizens have no inalienable rights. And that's absolutely true in a legal sense. It's completely corrupt in a moral sense, but in a legal sense it is 100% true, because in Dred, the court ruled that blacks brought to this continent for the purpose of slavery were not citizens of the United States, as that phrase was used by the men who wrote and ratified the federal Constitution. That they could not be considered to be citizens of the states. Okay? Only de jure citizens of the states were seen in law as having inalienable rights. I have inalienable rights. You have inalienable rights. But a freed black slave was, under the laws of the states, not a citizen. That was the whole problem at the end of the Civil War. You had all these people who were free, but they were not citizens. And they couldn't be made citizens. In other words, it couldn't just be like, okay, you're free, so now you're citizens. That couldn't happen because under the state constitutions, the word citizen didn't embrace slaves. And simply freeing them didn't change the fact that they were not meant, it was never intended, that word citizen, was never intended to cover them when the state's constitution was written. And remember, the preeminent rule of constitutional construction and interpretation is the words mean what the men who wrote them believed them to mean at the time. So, Congress came along, and through the 14th Amendment, in other words, we all came along, the de jure class of citizen, and we gave certain statutory, quote, rights to the freed black slaves. They don't have inalienable rights, and that's what the mass court is talking about.